Thank you so much for a great book and a great story, and that was just a really great summary. So thank you so much. Hopefully our audience got all of that. I actually would love to start with the Nuremberg trials. You've also written on the Nuremberg trials, and kind of what I think is really interesting about this book is that you talk about this as the last Nazi war crimes trial, and in a way the sort of final resolution of creating a legal category and a legal answer to how we talk about perpetrators. And that sort of started in a way at Nuremberg, right? And so I'm wondering if you can expand a little bit on that. Sort of what is the journey of trying war criminals and the journey of legal solutions to guilt and crimes against humanity?
Right. So as some of you might know, well, the Nuremberg trial, when we talk about Nuremberg, there were kind of, sometimes you see it Nuremberg trial, sometimes you see Nuremberg trials. I'm going to focus on Nuremberg trial, and just so for the audience, just to clear up that confusion. The Nuremberg trial, when we talk about the singular, we're really talking about the trial that was conducted by the Allies. It was an international criminal trial, the first international criminal trial in human history, in which the 21 major Nazi war criminals were in the dock. It just so happens that because the Allies had refurbished this courtroom in Nuremberg, the American military then conducted a number of follow-up trials of other Nazi perpetrators not as high up. And the Americans conducted 12 subsequent trials, and that's what's referred to as the Nuremberg trials. So one of the distinctive things about the Nuremberg trial, the international trial, as you suggested, it is, it's the first such tribunal in history, and we should bear in mind that the main crime that was brought against the major Nazi war criminals, it wasn't crimes associated with Nazi atrocity. The main crime that they were charged with was launching a war of aggression. That is, the main charge was that they committed crimes against the peace, that they had launched an aggressive war in violation of international law. But that said, they also, the Nuremberg trial also was the very first trial to offer judicial recognition on exactly what you described, this category called crimes against humanity. And crimes against humanity was the charge that most of the evidence of Nazi atrocities, such as the extermination of European Jews, most of the evidence was brought through that novel legal channel of crimes against humanity. And the other very important new legal channel that was developed in response to Nazi atrocity was the concept of genocide. So genocide was a term that was coined by Raphael Lemkin, who was a Polish Jewish jurist who in 1944 was working for the US War Department. And at the time, he was trying to come up with a new term to describe what was happening to Jewish populations in occupied Europe. And he took a Greek root for group, genos, took a Latin root for killing, side, put it together, and created this new term, genocide. And already by 1948, the UN had elevated this new term, genocide, into denoting an independent crime in international law. And so the two really important breakthroughs for dealing with these kind of state-sponsored atrocities was the development of the concept of genocide on the one hand, and the development of the concept of crimes against humanity on the other. And even to this day, they remain the principal conduits for dealing with state-sponsored atrocities.
What you're showing in the book, does that work? Yeah. But the introduction of this novel concept of crimes against humanity in 1945 at the Nuremberg trial meant that these defendants were tried on a legal concept that did not exist at the time of the commission of the crime. So it had to imply then retroactive law, which was defended on the grounds, well, this is extraordinary, these are crimes against humanity. But then what your book shows, since Danyliw was tried in 3 different countries, is that this concept, even though devised largely by American lawyers, did not carry over into American trials. That was rejected, well, that was just simply not used, perhaps out of ignorance, but it was more like pointedly rejected by West Germany
Yes.
So all the post-war, not American trials in Nuremberg, but German trials also rejected the notion of retroactive law. And even in Israel, I think Eichmann and then Demjanjuk was tried on crimes against the Jewish people, not crimes against humanity.
Yeah, so if I can respond to that. So one of the things that, one of the charges that, one of the arguments brought against using crimes against humanity and genocide is exactly to say it represents the application of retroactive law. Retroactive law meaning that, just so everyone in the audience is clear about that, so the idea is that there seems to be something kind of fundamentally unfair about trying someone for conduct which was not criminal at the time that they engaged in it. Now, lots of jurists, and I would be I would include myself in this group, would say that, well, there doesn't really seem to be something fundamentally unfair about trying people for things like the killing of civilian populations, because it's not as if they weren't on moral notice that they were doing something wrong. So whereas trying someone for driving 65 miles an hour at a time when it was legal to do so, but then you suddenly retroactively change, that seems to be fundamentally unfair. And I should mention that every European country, the European Convention on Human Rights was framed in 1950, and the European Convention on Human Rights enshrined the bar against retroactive law as one of the basic principles of European law. And yet the European Convention on Human Rights specifically said, oh, we just want to make it clear to everyone, Nuremberg was not retroactive law. Crimes against humanity, genocide, there's no problem with there because you're not violating any fundamental principle of fairness. So if you look, for example, at Israel actually, these crimes against the Jewish people really is an example of crimes against humanity and genocide just kind of incorporated into Israeli law. They basically use the template of crimes against humanity, genocide, they incorporate it into domestic law, they just change it a little bit. If you look, for example, France does the same exact thing. They basically take Nuremberg's definition of crimes against humanity, they incorporate it into domestic law, and then they use it for the purposes of trying people like Klaus Barbie, the so-called Richard Lyon, and other Nazi war criminals in post-war France. But you're absolutely right, the one country that really rejects the use of crimes against humanity and genocide as a tool for dealing with Nazi perpetrators in the post-war years is West Germany. And I wish I could say that the West Germans were prompted by incredibly deep feelings of being very fair to these former perpetrators, but I don't really think that's the story. I think a lot of what was going on there, unfortunately, is that they were all, the short story is, the post-war German judiciary was filled with former Nazis. And they erected all sorts of obstacles, self-serving obstacles to the prosecution of former perpetrators. And one of the obstacles I think that they put in place was a refusal to use these new incriminations that had been designed to facilitate the prosecution of former Nazis, that is, crimes against humanity on the one hand, and genocide. And then, as I tried to describe in the book, because they turned their back, they refused to use genocide and crimes against humanity as charging statutes, it creates all sorts of problems for these post-war German prosecutors because it raises the problem, what are you going to charge these former Nazis with? Now, I could go on that if you're interested, or want to kind of open up to other questions. And
Yeah, actually, can you just take that one step further as you do in your book, right? One of the problems is they had that, was it Einzeltätigkeit? That you have to show that this person actually did this one thing, right? And that the sort of the legal innovation is the potential perpetrator being in the place necessarily means he was a part of that process, right? That's a shift.
Yes, exactly. So if I can, exactly. So just to expand on that a little bit. So once these German jurists said, well, we can't charge anyone with genocide or crimes against humanity, they have to ask themselves, what can we charge them with? Well, if they're so concerned with retroactivity, basically their legal profile has to be, we have to charge them with a crime that was a crime at the time, a crime that was recognized as a crime during the Third Reich. Okay, well, one possible conclusion they could have reached was that, well, we can't charge anyone with anything because they weren't violating any domestic national law that was in place at the time. Now, that conclusion, which would have meant that in post-war Federal Republic of Germany, you couldn't have tried any perpetrator for anything, I think the technical legal term for that conclusion would be crazy. That would be a crazy result. I mean, if you think about it, because it really would have kind of incredibly impugned the effort on the part of Germany's effort to kind of rehabilitate itself as a country of the rule of law, as a fledgling liberal democracy. So they had to find something. And the thing that they seized on was, things like the conventional murder statutes. And so they basically, now they had to treat state-sponsored extermination as if it were really no different than a kind of convenience store killing. And in a convenience store killing, German doctrine had said, well, we need to show that you engaged in a hands-on active killing. Well, a hands-on active killing makes a whole lot of sense when you're treating murder as a convenience store kind of killing. You go inside, he had the gun, he shot the clerk, we arrested him. It doesn't necessarily apply particularly well when you're trying to wrap your head around things like state-sponsored atrocity. And so that doctrine, using the simple murder statute, created incredible obstacles to successful prosecution. Not to mention that you needed witnesses. And particularly if you're dealing with things like extermination processes, comes as no surprise that there are not a lot of witnesses around to testify. So the obstacles to successful prosecution were very, very great. And then, as you mentioned, kind of what happens in the Danyliw trial, which is kind of a very, very important breakthrough, though very late in coming, we have to observe, is that what they basically say is, what the court says is, well, if you are working in some place like a death camp, in which really the only purpose of that camp is to produce corpses, it really is a factory of death, then we don't necessarily need to show that you engage in a hand-on act of killing in order to convict you as an accessory, because by virtue of having participated as a guard in such a camp, you necessarily were an accessory to murder, because in a sense that was your job description. And so that's where they pioneered this theory of what I describe as kind of functional participation. So guilt no longer turns on the actual specific thing of, oh, we saw you kill that particular person. It turns on the fact that you participated in this killing operation.
If we can backtrack a bit, because the Munich trial, of course, comes very late when Danyliw is 90 years old, and he has undergone several trials in the United States and a major one in Israel. So let's go back to the United States, because that's where it all started in the 1970s. Danyliw never faced a criminal trial in the United States. He had a number, at least two, and then a subsequent follow-up, let's say, proceedings. These were civil cases of denaturalization, that is losing your citizenship, and then extradition to send them to Israel in the 80s. What was he charged specifically with? What was the legal, concept used to charge him?
So in the United States, when it started dealing with this problem of collaborators within the country, that is Nazi collaborators, it really wasn't until like the late 1970s that the United States started taking the problem of collaborators seriously. And the question was, what could prosecutors do? And in the United States, again, this gets a little bit in terms of technical legal grounds, but it was not possible. These were all crimes that had taken place extraterritorially, outside of the United States. And because these were extraterritorial crimes, for technical legal reasons, American courts would not have jurisdiction to bring criminal charges against alleged collaborators. So the one thing that they could do is they could bring basically civil immigration charges against them. And again, this was a kind of, just as I said with regard to Germany, that suddenly you had to take acts of state-sponsored extermination and kind of pigeonhole it into an ordinary murder statute. Well, American prosecutors also faced somewhat of a similar problem, that they also had to deal with, again, less with perpetrators, more with collaborators. But still the question was, the issue that they had to face is they had to take evidence of collaboration in exterminatory actions and pigeonhole that into an argument that said, well, what they had done is they had entered the country in the first place under false pretenses in violation of civil immigration law. And so the only thing that we can really do is we can work, if they have American citizenship now, we can denaturalize them for having entered the country under false pretenses, and then we could deport them to a country that they could either just live in, or that because of, this is where the crimes actually took place, would have jurisdiction to bring criminal charges against them. So that was how basically the United States handled all these collaboration cases, as ultimately cases in which people had entered the United States by withholding evidence which, if known at the time of their entrance, would have been grounds for barring them from being coming to the country.
So you have this incredible, really transnational story, right, of different legal systems trying to come up and create solutions to this legal problem, and kind of looking at each other, right? And the one player that I'd like for you to elaborate on is the Soviet Union, right? Because they are a player in this as well. So how did Soviet case law play a role in this story?
Well, the Soviet Union, it's a complicated thing. I mean, it's complicated even in the sense that the one question you might want to, that I think is implicit in what you're asking is, like, how did Americans even first get information about, how did these American investigators in the mid-70s get information about Danyliw? And it seems like that information was basically leaked by the Soviet Union to a sympathetic person in the United States, who then passed that information on to American investigators. And this is in the height of the Cold War. Why is the Soviet Union even giving this information to the United States? And I think they're trying to do two things. I think on one level, the Soviet Union is certainly, it's in their interest to show, oh, look at all these collaborators in Nazi crimes who have been settling in places like the United States. I mean, another country that takes immense glee in revealing the degree to which former Nazis are now in positions of power is East Germany. East Germany is constantly doing things like publishing lists of former Nazis who now occupy positions of power in West Germany. The other thing I think the Soviet Union was doing at the time is there were two rather large anti-Soviet groups in the United States at the time. In the mid-70s, you have the Ukrainian community and you have the Jewish community as well. This was a time, particularly if you might recall, about free Soviet Jews. And I think what the Soviet Union was trying to do was drive a wedge between those two communities. Instead of having these two communities allied in anti-Soviet feeling, I think what the Soviets were trying to do is, by leaking information about the presence of Danyliw in the United States, we were trying to drive a wedge between American Jews on the one hand and American Ukrainians on the other. The other thing I think is interesting to observe is that this whole, in a sense, this kind of legal fiasco which unfolds in Israel in the trial of Danyliw as Ivan the Terrible. If the Soviets had been more open in revealing what they had, information that they had in their own files, that could have been completely avoided. they had information that they were sitting on that made very clear that Danyliw was not Ivan the Terrible. And the question is, why did they sit on that material? That is why they didn't release it to the Israelis or to the Americans. And it seems like there are a number of different theories behind this, and I tried to look at this pretty closely in the book. One thing is that they didn't care. That they, that the Soviets had, I think at one point in the book I mentioned something along the lines of, the Soviets, they executed people on completely trumped up charges, so they didn't really care if if they execute the right guy for the wrong reasons, who really cares? So that could be one thing. The other thing is that they were not particularly invested in seeing, if the Israeli legal system gets egg on its face, that's fine with the Soviet Union. So it might be even something that they were kind of hoping that the whole thing would explode and show the incompetence of American and Israeli investigators. That's possible. And the other possibility, which is, in many ways the least sexy of them, is that they didn't realize what was in their own files. That these things, they had acquired hundreds and thousands of pages, which at some point people had, KGB people had looked at very closely. But now decades had passed and no one really looked at these files, and no one really knew exactly what information they had.
On the question, the nuclear question, I would say, of Soviet evidence, or the validity of Soviet evidence, probably the most examined document in recent legal history has been the famous Ident ID, or identification document of Danyliw as a travniki, as one of these auxiliary guards. And by the way, it's not in territorial Ukraine, that was in General Gouvernement outside of Ukraine, in occupied Poland. That has nothing to do with the OUN and the UPA. Here we're talking about a very different group. So that famous card that shows, that indicates that he served in particular in Sobibor, not Treblinka, but Sobibor. So that card has been examined repeatedly in the civil cases in the United States, then in Israel, and then in Germany. A whole book, you kind of wrote a book, not just on the card, but it's amazing. A consistent argument of Danyliw's defense is that you cannot trust Soviet evidence. This is fabricated. That's fabricated evidence. But then a rather spectacular, literally life and death denouement of his Israeli trial, as you pointed out earlier in your presentation, is that he was exonerated because the Soviet Union was collapsed, and suddenly evidence was available, in particular from another case of Travniki, a fellow Ukrainian who immigrated also to the United States, Fedorenko, who also was tried in civil case in the 70s. He actually admitted that he served in Treblinka, and he was then extradited to the Soviet Union. They tried him in Crimea, and they shot him, and basically the death penalty. But in the trial, as you said, the documentary evidence exonerates Danyliw as Ivan Grozny. So here we have the contradiction of, on the one hand, you can't trust Soviet evidence, but then Soviet evidence ends up exonerating, in this particular case, Danyliw.
Yes, even though, again, it's a very interesting thing about the trustworthiness of Soviet evidence. And I think that maybe it's a little bit more nuanced than that. I'm not to suggest that you weren't also capturing those nuances, but one of the things is that I don't think anybody today believes that the Cherniki card was falsified, his ID card. One of the things that lent support to the argument early on that it was a falsification is that no one had seen one of these Cherniki cards before. At the time of his first denaturalization proceeding, again, now we're going all the way back to the late 70s, early 80s, this Cherniki card was something very exotic. The Soviets had basically passed it on to the Americans. You had even, experts in Nazi genocide looking at it going, it looks authentic, but we've never seen anything like this before. After the unraveling of the Soviet Union, that I mentioned coincides with the appellate phase of his trial in Jerusalem, when all these investigators and historians get access to these KGB files, well, then they find dozens and dozens of these Cherniki cards. So suddenly the Czerniki card is, oh, it's not an exotic one-off specimen. It's like, yes, these were what the service cards look like, and we now have them for all these other people. We have them for many, many other people. So I don't think it's the case that, and for example, even if you look at the argument by the defense of Danyliw in the Munich trial, the defense which was basically headed by this German lawyer named Ulrich Busch. Busch completely backs off on the argument of the falsification of the Czerniki card. He basically, I mean, there is, you know, he kind of makes that gesture, because defense lawyers don't make all gestures, but that's not at all really part of it. I mean, I don't think anyone could really seriously challenge that. I think the area in which the Soviet documents have to be taken a little bit more with a grain of salt is the kind of interrogations that Soviets had conducted of, you know, lots of other Czerniki officials. And you always have to be wary of that, because there's coercion involved, and obviously something that even the United States now knows, that confessions that are elicited under coercion are not necessarily reliable. And so that's the kind of information I think that really needs to be taken with a grain of salt, less so the documentary evidence, which I think really has stood up to basically all good faith efforts to examine its authenticity.
So as a historian, I just have to ask you to elaborate more on the role of historians in your story. Was one of the things that I thought was particularly interesting was the way that part of the Danyliw story is the development essentially of Holocaust historiography, right? And the way that scholars have, with new documents and new interpretations, right, changed and transformed their understanding of this event, right? And that actually it's the work of historians understanding these camps and understanding what went on at these camps, since of course there were, you know, a handful of survivors, if that, right? That that really transformed the possibilities for the legal system. So I'm wondering if you can elaborate on that a little bit.
Yeah, so even when, for example, these various investigatory bodies, I mean, I'll talk about, for example, the United States. So the United States in the Justice Department creates in 1979 this separate body called the Office of Special Investigations. And this Office of Special Investigations is tasked with dealing with these, bringing in these civil charges, these immigration charges against these collaborators. And what they realized early on is typically if you go to the Justice Department, a Justice Department division will have lawyers and will have investigators. Investigators will be like people who will, you know, uncover evidence, and they realize these investigators, we can't use that model. We need people who are experts with language, documents, and history. And so basically they get rid of all their investigators and they hire professional historians. They hire people with PhDs from Columbia University and these people really kind of make possible the mounting of these cases. And just to give you an example of the kind of breakthrough in doctrine which is made possible by by historians, I'll switch over to Germany now. So one of the things, if you look at some of these early trials in Germany, a lot of these early trials that take place in Germany fail because the defendants come forward with an argument of what we describe as either, in law it's described as either necessity or putative necessity. And necessity is basically, I think it's an idea that's familiar to all of us. It's the idea that, yes, I did engage in a criminal act, but I did it because I was forced to. Someone was holding a gun to my head. So I was in peril of life or limb. And then the putative necessity is just a variation on that, which is, okay, maybe someone wasn't really holding a gun to my head, but I really thought that I was under peril of life or limb, and that belief was reasonable at the time. And there were a lot of, leaving aside, you know, these lowly collaborators, there were SS people, like pretty important SS people who succeeded mounting that defense. They were acquitted. They acknowledged they engaged in criminal acts, but they had to do it. Well, historians engage in an incredibly detailed and exhaustive effort to look at, well, what happened to SS people who opted out of genocide? Now, again, I'm not talking about SS people who resisted Hitler. That's a whole other thing. I'm just talking about SS people who said, when I signed up for the SS, I never really signed up for exterminating men, women, and children. It's not for me. Give me a different job. And what these historians were able to discover, and it's really a shocking discovery, is that the total number of SS officials, German NCOs who suffered draconian consequences for opting out of genocide, that number is exactly 0. There's never been a single case discovered. Now, is that because there weren't any cases? No, there actually were cases. There were cases of people who opted out. Was it a good career move? No. If you wanted to kind of like make your name in the SS, of course it wasn't a brilliant idea to say, I don't want to do this. Could it get you ostracized from the community? Yeah, all sorts of unpleasant things. But would it get you lined up against a wall and shot or thrown in prison? The answer is no. And once historians were able to make that breakthrough, suddenly German courts became a lot less receptive to this argument. And so it's a perfect example of the way in which a more sophisticated historical understanding of the operations of the SS made possible a recentering of court decisions.
But could the argument be made, the argument was made in the court of law, that the situation was different from auxiliary police? They were not ethnic Germans, they were not high-level SS, they were, again, police. And perhaps in their cases, again, the argument has been made that they would have been lined up. You can't, if you're in the Travniki camp, you're sent to Sobibor, you can't leave. If you're captured, you'll be shot.
Exactly. So this whole problem of the auxiliaries, of these Triniki trained guards, someone like a Danyliw, that in many ways was a additionally fraught issue. So even if we can say with certainty that, well, people like SS, that argument about putative necessity, that doesn't wash. What about the case of people like Danyliw? Because as you point out, not a German, not a Nazi, not even really volunteered for this position, was picked out of a POW camp, then trained. What can we say about people in that position? And to make your point even kind of stronger, there was a German prosecutor who actually prosecuted SS men, Helge Gravitz, who in 1988, she wrote a book saying like, well, the Triniki people, that was a very different issue. These are people who probably would have faced really draconian consequences. So again, a very, very exhaustive historical effort was devoted to trying to figure out, well, what were the kind of constraints that these Triniki men were operating under? And a historian named Peter Black wrote a kind of, a rather exhaustive answer to that. And what he tried to show was that, these Triniki guards, that they really were rather valued assets in the SS. Some of the things that he pointed out, so for example, at some place like Sobibor, Sobibor was a relatively small camp. There were only 15 or 20 SS men and about 100 to 120 Triniki guards. Now these Triniki guards, they were armed with rifles, sometimes with automatic weapons. They drew salaries, they drew paid home leave. And this Peter Black was even able to identify Triniki men who opted out, who said, this is not for me. And they basically suffered, again, no draconian consequences. So I do agree that the auxiliary, that does represent a different problem. But it does seem that the evidence suggested that, again, when they're outnumbering the SS members by about 6 to 1, and they're armed with automatic weapons, it's hard to make the argument that, for example, the defense in Munich made, which is, well, they're just prisoners in a position not that different from the Jews themselves. That is, if you had to kind of create a continuum and had the Jews on the one hand and the SS higher-ups on the other, I don't think we would put the Trinikis over here. I don't think we'd put them, we put them more in this direction. And the other thing that I think is worth pointing out is that, again, we can argue about the relevance of this, but the prosecution pointed out that lots of Trinikis deserted. They actually deserted there, particularly towards the end of the war, where it became clear that the cost of collaborating with the SS could be very, very high. I mean, once you start hearing the Red Army artillery in the distance, you can start to question the wisdom of working now with the SS. So there were very, very high desertion rates. And they were able to say something about the consequences of desertion as well, these historians. What they were able to say is that if a Triniki guard deserted with his weapon, then he was assumed to be joining the partisans, and if he was captured, he would be shot. So that's draconian consequences. But if they deserted and left their weapon behind, and they were caught, well, then they would get kind of like a hand slap punishment, and then move right back in their guard service duty. Now, again, this also raises an interesting question, which is, what would Danyliw have known at the time? Because it's possible that he didn't know that there was such a difference between leaving a weapon behind or taking a weapon. But the one thing that I try to argue in the book is, in a certain way, Danyliw, by always denying that he ever served anywhere at any time, in a certain way he made the argument a little easier for the prosecution. Because if you're going to argue, let's say, necessity or putative necessity, you have to say, look, I was at Sobibor. I tried to be a decent person. I saw one guard being brought back after escape, and he was shot. I didn't know he was shot because he had his weapon. I was terrified. It's hard to make that argument if your argument is, I was never there in the first place, but if I had been there, I only would have stayed because I was terrified. That doesn't really make sense.
Point about pursuit, if I can.
And we should open it up.
Yeah.
Yeah.
Actually, your book shows that he could never make that argument.
Yes.
Because of the Supreme Court ruling in the United States in the 1970s, that the mere presence, no matter what you do, in not even a death camp, a concentration camp, is sufficient for you to be deported on grounds of persecution of civilians. So he basically was in a legal bind, wasn't he?
Exactly. No, I agree that. There were two questions. One was, if he was interested in returning to the United States after the Munich trial, if he was interested in trying to return to the United States after the Munich trial, there's no way that he could acknowledge that he had been at Sobibor, because the acknowledgement that he had been at Sobibor would have meant that he was barred from returning to the United States. The only thing it would have done is that it would have arguably made possible his acquittal. Even then, it's hard to say, because it's one of these things where, once one has fabricated a story over decades, and then suddenly seems to instrumentally back off from that story, it does raise this question of, well, what are we supposed to believe at this point? I mean, what is the truth? So, as I try to, as sympathetic as possible in the book, there were instrumental reasons why he should fabricate stories, and it's not surprising that he did, but it does bind you. Once you have a story of lies, it does constrain you in what you then can say further on down the road.
No, I think we should open it up to the group. I'm sure there's a lot of questions out there. Yes, on the side.
Thank you very much. Fascinating stuff. I was marginally involved in some of this in a previous life, but I think some of us remember what happened in Canada, where I think, like the United States, Canada did try to run a judicial process on certain war criminals. And there were cases, and I'm thinking of the case of Imre Finti, the Hungarian, where the jury would not convict because they felt there was reasonable doubt. So in the end, the government decided to strip citizenship and deport that way, and using the argument that immigration and citizenship was based on fraud. And this is an interesting argument. It's been effective, but I have to think right now on the Hill over there is a case where citizenship and permanent residence and refugee status may well have been granted through at least misrepresentation. So in the end, it's how effective is it? And I suppose in the end it serves, there is a political dynamic involved, because governments may be interested in pursuing some cases, but as we see most recently, they're less interested in pursuing others. So I'm just wondering if you would comment on that.
Yeah, I suppose, the Finta case was something where, as I was saying, there might be something kind of odd about taking acts of complicity in state-sponsored atrocity and just treating it in this, relatively, we might say, trivial fashion of just, lying on immigration forms. That might seem like an odd thing. On the other hand, there were American, prosecutors who said, the Finta case is a good example of the incredible difficulties about getting juries to convict extraterritorial crimes. It's very hard for them to deal with crimes that took place thousands of miles away, arguably decades earlier, in which the people who are testifying have strange accents and are hard to understand. And so one of the takeaways from the Finta case in the United States was in many ways to say that while our strategy, as limited as it might be, it actually is a little bit more efficacious. It is kind of better for us maybe not to be using criminal charges in this country, and it is better for us to kind of just treat it as a civil case, and then we can deport them, to deport these collaborators to countries that are capable of really mounting a successful criminal trial. And so in a certain kind of funny way, the Finta case was a vindication for American prosecutors of their approach.
On the German selection of Danyliw, wouldn't it have been more effective to select a German who worked with Danyliw or in other camps as proof of the newer concept of being a member of an organization rather than individually responsible? Why was Danyliw in particular chosen?
Yeah, well, I mean, it's a good question. And I should point out that since this breakthrough in Munich, there have been additional trials. There were 2 additional convictions, not of non-German auxiliaries, but of actual SS men. There was a conviction of this Oskar Grönig in the summer of 2015, and then just this past summer there was this conviction of Reinhold Harlig, again, both SS men, who were convicted using this theory of functional participation that was pioneered at the Danyliw case. And then there's actually a 3rd trial that's going on right now, even though it looks like with this guy, Herbert Zafka, though it looks like that case might unravel because of the defendant's ill health. And I do think it is the case, one of the ironies is, I do think it was the case that they chose Danyliw rather than, let's say, Grönig as the first person to try. I think they did it for a couple of reasons. One is Sobibor was really kind of a pure death camp. And so it was kind of a very good place to pioneer this theory of functional participation. The other thing that I do think it's an irony is that I think they seized on Danyliw because he was a notorious figure, but he really was a notorious figure because of the case of mistaken identity. So so there is a little bit of an irony involved there, and I could imagine that if I was Danyliw, he could, even though I do think I support the decision to try him, and I support the conviction. Like many people, I don't think there was really any purpose served in actually sending him to prison. So I thought there was really something quite brilliant about the German decision, which was to convict him and then to release him pending appeal, and then he died during that appellate process. But I do think it is the case that he probably wouldn't have been on people's radar if he hadn't had this case of mistaken identity. So in many ways, he was the poster boy for the high-profile collaborator, even though we now know that he was a very low-profile collaborator.
Let me link this to a broader point, which is selective prosecution. And the first gentleman said, you know, the prosecutors in Canada, they have to decide to go after this guy or this other guy, etc. We had a discussion yesterday in a different context about the Security Council and the power of veto of the P5 members. That includes Russia, the United States, China, of course, Great Britain and France. And the reality, and then us linking here the history of these legal cases in 3 different countries to the contemporary situation with what we generally refer to as war crimes trials, or now the International Criminal Court. The International Criminal Court has only cases in Africa right now. As a fact, everybody knows that none of the P5 countries, individuals from P5 countries are most unlikely to reach the stage of an international criminal trial because of the power of veto. So there's a mechanism here of selection. In the rather unusual and extraordinary case of Danyliw, he was tried 4 times in 3 different countries. And certainly in this case, a reasonable question is why systematically and repeatedly go after the same guy at a time when in Germany, his superiors were being either acquitted or given rather lenient sentences on the grounds precisely that that they were there involuntarily and they would have been killed if they didn't follow orders and so forth. So the broader question is, what do we take from your, let's say, legal journey into the present with this thorny question, issue of selective prosecution on political grounds?
Yeah, I mean, it's an excellent question, and it's a pretty fraught question. The issue of kind of selective prosecution is, well, there's several ways to kind of respond to that. One thing that, if we look at, in the case of, let's just focus for a second on West Germany, or the Federal Republic of Germany, where I don't know if it's necessarily the case that in Germany that you find lots and lots, well, let me take that back. You do find some cases like, but you generally find German prosecutors attempting to prosecute higher-ups and then often failing. And they often fail for these reasons that I kind of suggested, things like these arguments of punitive necessity. Now, the unfortunate thing about this is, a lot of people have said that, well, Danyliw was tried way too late. I mean, this is now 70 years after the crime. This 89-year-old man at the time of the start of the trial. But one of the things that I think I tried to illuminate in the book, the irony is that it's less that Danyliw is tried too late. In certain ways, it was the higher-ups. They were tried too early. And by too early, and this goes back to the question you had asked, they were tried too early because they were tried before the historians had sufficient evidence at their disposal to be able to say that, this argument about necessity and punitive necessity, it's all BS in a way. And if they had had that understanding earlier, or if these trials of the higher-ups had come later, the irony is they probably would have gotten much higher conviction rates and much longer prison terms. So that's one of the ironies. So, with the selective prosecution, it's not so much that Germans said, oh, we're gonna shield this higher up from trial, and we're just gonna go after this lowly minnow, which really does seem deeply, deeply problematic. It's more like, oh no, we are going after this higher up, but we've screwed up because we don't yet have the legal tools that make possible a successful prosecution. And it is, of course, an incredible shame that those legal tools aren't pioneered for decades and decades and decades. Now, again, you could also say that, well, it's no accident that they're pioneered only decades after the fact. I mean, isn't it kind of an irony that they only get pioneered at a time when suddenly all the real higher-ups are either dead or shielded from prosecution because they've already been prosecuted once and acquitted or given very minor prison terms. And it's only then developed when the generation of the perpetrators has passed. And I think one can be cynical about that. There's no doubt about it. On the other hand, the other thing I would say is that even this breakthrough that was achieved in Munich, there was nothing inevitable about that either. I mean, I think, having talked enough with German prosecutors, there are people who, spent their careers trying to develop this theory earlier on. And, they engaged in good faith efforts. And so I think the cynical story has to be balanced. It has to be balanced against the fact that you really have people who are incredibly dedicated, who work their entire careers trying to bring higher-ups to justice. And so it's not simply the case that, the higher-ups get a free pass, and it's only the lowly minnows who end up paying for the crimes of the higher-ups. I think it's again, it's not a happy story, but it's certainly a little bit more complicated story than that.
Other questions? Yeah.
Oh, sorry if this has been dealt with already. I'm just wondering, since his case was under appeal when he died, does the conviction still hold?
As a technical matter, he is technically considered legally innocent because the conviction was never upheld. So I guess there are two questions, like what is his technical legal status? And the technical legal status is convicted, but the conviction never took legal effect. Then I suppose the other question is, well, does that still then supply a model for other prosecutions? And there the answer seems to be yes, because as I mentioned with this Grönig, these two other SS and three other SS cases have all been based on the Danyliw theory. And so the theory has basically been accepted by other prosecutors, even though in his particular case, you could say that technically his conviction never took legal effect.
Actually, I have a question. It's on the role of the witness in these trials.
Yeah.
Now, the Eichmann trial was the trial of the witness. That was the breakthrough. The Nuremberg trial was spectacular for the first trial in history, but once the first few days were gone, it was basically pretty droning because it was all based on the reading of documentary evidence. There were very few spectacular witnesses. The Eichmann trial is the first time we have survivors of the Holocaust actually speaking out, even in their own country. So it was like the voice of survivors, the witnesses, even though what they were saying had directly little legally to do with Eichmann because they never met him, and they were basically testifying on their experience of the Holocaust, but not specifically about Eichmann. But it was deemed as a breakthrough. Now, your book shows that because of the right, wrong man, based on, again, the testimony of witnesses, they were absolutely convinced that he was the Ivan Grozny, and there turns out he was the wrong man here. So the witness, in a sense, as a key component now of war criminal trials was shattered. And yet, in the 1990s, in parallel, we have the role of the witness in the Yugoslav trials, the ICC trials, and in particular, even the Truth and Reconciliation Commission. So it's all over the place. Even though your book showed that as a legal journey, it was actually a shattering discovery about the perhaps unreliability of witnesses, particularly with the distance of times.
But can I just build on that quickly, because I think one thing that that you show is the importance of the didactic trial, right? There's this idea of the didactic trial, that whether we're getting ultimate justice or not, we're getting information out there. And I wonder if there's a way that, historians wouldn't know what they know without these didactic trials, without those oral histories, and without that going on the record, right? Would they have been able to come to this conclusion where we then don't need the witness testimonies, right? That there is actually an ultimate purpose to those didactic trials, even if you show legally they didn't quite work.
Yes, exactly. Well, I think in a certain way, I think you're both right. I mean, I think you're both right in the sense that in many ways, the Eichmann trial is probably the most successful example of a didactic trial. It's the most successful example of using, basically telling Holocaust history through the lived memory of survivors. And it becomes incredibly successful, not just in terms of riveting interest in Israel. I think the Israeli prosecutors themselves were astonished at the degree to which it garnered international attention. Certainly in West Germany, it became an incredibly important event, I think in the United States as well. you can flip it around and say that the Danyliw trial in Israel really showed the dangers of a didactic trial. That when you try to use legal proceedings for the purposes of teaching history, can really kind of blow up in your face. And I suppose that maybe the takeaway is that that the role that survivors play in these atrocity trials that have a didactic function is almost best limited to narrating their story and to give a human face to the suffering that state-sponsored or even non-state-sponsored atrocity causes. And when you enlist them in kind of the more classic legal function of eyewitness testimony, well, eyewitness testimony, it's sad to say, it's always very, very fraught and unreliable. And I actually kind of go and try to go into the book as to how is it that these people who swear with absolute certainty to recognize this guy, how did they all get it wrong? And I think I offer what I think are some plausible theories. But even if you didn't have to look into this particular case, I think any trial lawyer will tell you should be very, very suspicious about people who have suffered great trauma. I mean, our heart goes out to these people. You want them to be right. So there's a natural inclination to hope that their identifications are accurate. But I think, in general, when we're talking about even like the Slavic Tribunal, the ICC, I think, or the Truth and Reconciliation Commission, I do think that survivor testimony can play an incredibly important role in helping to learn about the history of atrocity. I think we should be just a little more careful when it comes to very specific acts of eyewitness identification.
We have a question right here.
Just to catch up on that.
We need the microphone.
I believe that also applied to witness risk in the David Irving Holocaust denial libel suit back in the 90s, I think it was, when he took an author to court in the British Courts of Justice, and there were attempts to bring witnesses to testify that there was a Holocaust, they survived it, they saw it, but the legal team stressed the importance of proving or disproving Irving's deliberate misrepresentation of history as opposed to relying on spurious evidence of witnesses. So but the challenge is, as Dr. Arell says, how do you apply consistency? Because sometimes you have it and that. The other question I had is, if I may recall, I could be wrong, I thought one of the breakthroughs of the Nuremberg defense, not the big trial, but the trial subsequently, and then Eichmann, was the loss of the defense, following orders defense, that I was a cog in the machine, as Eichmann said. So, and I think that's, do I understand correctly that the auxiliary defense also falls under that rubric as well?
Did you hear well the two questions?
Yes. I think I got both parts of the question. So I think the second question was the defense of superior orders, and I think that's right. I think one of the things that Nuremberg did is it basically refused a defense based on superior orders. I mean, technically, what Nuremberg said is that superior orders does not excuse engaging in manifestly criminal conduct. What it can do is it can be considered in mitigation of punishment. So it can be used for the purpose of mitigating punishment, but it cannot be used for the purposes of eliminating one's guilt for following manifestly criminal orders. And then the first question was about the David Irving Dipper-Lipstadt case.
There's a movie currently playing called Denial about this
Holocaust.
case.
So Irving, it actually was just made into a movie. But did you just say that? Denial, this movie with, yeah. So as soon as it hits Hollywood, you know that it's, really big. But David Irving was a British historian who then kind of drifted into Holocaust denial. And I think one thing that did take place at that trial is that when you're trying to deal with the hateful arguments of deniers, it is always probably stronger to rely on actual documents than rely on survivors, because survivors, especially if they're older, any defense lawyer worth his weight can usually make people look bad under cross-examination. And so, I've studied the record of some Holocaust denial trials, and they'll be asking things like, okay, you claim to have seen the crematorium. How high were the flames coming out of the crematorium? What color were the what color were the flames coming out of the community? So they can ask these incredibly heinous and ugly questions. So I think one of the things that, documents can supply a kind of perhaps more solid, though, as we also learned from Nuremberg, a less interesting and less compelling argument.
I want to revisit the crucial issue of choice, which in the mass violence literature since the 90s with the Ordinary Men, Christopher Browning book, has been a major, spun an entire kind of body of literature. That is the idea that you have individuals, ordinary individuals, not socially deviant as such, just put in extraordinary situations. And then to what extent do they have a choice? To what extent do they have a choice to be there in the first place? So like for Danyliw, to what extent did he have a choice to be in the, he was in a POW camp, he ended up in Travniki.
Sure.
To what extent was that a choice for him? And then to what extent, once you're put in an extraordinary situation and then being told to engage in, let's say, violence against civilians, to what extent do you have a choice to do it or not to do it? So we've talked about it before, that the legal concepts initially was putative necessity, you don't have a choice, if not, you yourself will be victimized, even with your own life, or the new legal doctrine of functional, what do you call it again? Functional necessity.
Participation.
Yeah, participation, sorry. Now, you're claiming, you've made the case very decisively, that in order to develop these cases in the latter stages, we needed basically to involve professional historians. So these legal cases now are dependent on the extraordinary work that can be done by teams of historians. But you also argue in the book that deep down, at the root, the question of whether an act is voluntary or involuntary can only be deemed in a court of law and not by historians. Do you want to address what could seem to be, there seemed to be a tension at least in the argument?
Right. Well, what I meant by that is kind of as a technical legal matter, the question, actually I'm hearing echo now. Are you getting an echo or are we still okay?
No, we're not getting echo.
Okay, so I'll just continue. As a technical legal matter, questions of voluntariness, I just mean it has to be decided by a court. So for example, if you're dealing with something like premeditated murder, can a ballistics expert tell you that a gun was fired premeditatedly? No, I mean, they can tell you all sorts of things about the way in which the gun was used, but ultimately the question has to be decided by a court. And similarly, with respect to voluntariness, historians can try to illuminate the range of choices that were available to actors in the position. But ultimately, it's the court that has to decide, well, given the information we've had, we have to make a legal determination whether that was voluntary or not. And one of the things that the court works from the assumption of, and it's something that we can ask ourselves as historians or as jurists or just as people, the court works from the assumption that if you find yourself involved in an exterminatory situation, even if you didn't choose to be put in that in the first place. So let's agree that Danyliw, for the purpose of argument, he never chose to be thrust in that position. He finds himself in that position. So let's say we find ourselves in that position. What then is our responsibilities? And what the court's argument is, if you can get yourself out of that position without threatening your own life, you have a moral and legal obligation to do so. And we're recognizing that your choices are constrained. They're constrained in ways that I think all of us would ask ourselves, how would I behave in that situation? I don't know how I necessarily would behave in that situation. But what the court is saying is that you're in a horrible situation in which you are being impressed into assisting the extermination of civilians. And you have an obligation, if you can reasonably do so, to get yourself out of that situation. And the failure to do so means that you made a choice to remain, and you're going to be punished for that. Now, again, that punishment should all make clear it's not the punishment that the people who created these camps deserve. It's not the punishment that people who were eager, but it is a punishment. We recognize that you did a legal wrong and you deserve some form of punishment. And again, I guess I would accept that argument.
Does age enter into the picture? Because very often, those people individuals who find themselves in an extraordinary situation are very young men. Well, Danyliw was fairly young, early 20s. Sometimes you've got soldiers. They're conscripted, barely 18 years old, and they're being asked under, again, the kind of command structure to go against their own establishment and make a moral determination. Does that enter into the legal debates in the cases?
Again, I would say that it probably enters the legal debates more on the level of kind of what I said about superior orders. It would enter more in terms of mitigation of punishment than the question of overall culpability. That is, even in in a normal legal system, if someone commits a murder at the age of 21, or someone gets involved in a situation in which, I don't know, you're 22 years old and you have a bunch of friends who are involved in drugs, and you decide to engage in a drug sale and something goes wrong and someone gets murdered, and you're an accessory to that murder and you help her. I mean, does the fact that you're 22 years old obviate you of all legal guilt? I would say no, but I do think that if we're trying to create some kind of relatively compassionate and fair legal system, we might think about the circumstances in which a young person was operating under.
We have a question right here.
Hi, thank you for your presentation. It's very interesting. My question has to do with the idea of the collaborator. So that's something that is obviously very, very politicized often, in the context of Polish collaborators or even Jewish collaborators in the Holocaust. And I was wondering if we have a sense, or if your book kind of gives a sense of what the reaction to Danyliw as a collaborator was like in the Soviet Union, either at the time or even in Ukraine today. Do we see a reaction to this idea of Ukrainian collaborators in Nazi atrocities? Thank you.
Well, with respect to Ukraine, I mean, you probably are more of the experts on this than I am. But one thing I think I can say is, so when Danyliw had his citizenship stripped in the United States for the second time, so this is now early 2000s, the United States was looking for a country to deport him to. Now, we know that he was ultimately deported to Germany, tried in Germany, but the United States did approach Ukraine and said, would you take this guy? And Ukraine said no. And I can understand why Ukraine said no, because they're kind of caught in a difficult position politically. On the one hand, you could have people who, very anti-Soviet, people who would have no stomach whatsoever for trying Danyliw in Ukraine if he's deported to Ukraine. So on one hand, the Ukrainian government is saying, well, there are lots of reasons why if we do accept him, a trial would be kind of politically indigestible. On the other hand, we also don't want to be seen as giving safe haven to a collaborator. And so they're kind of caught somewhat in a bind between not wanting to try, but also not wanting to be seen as offering safe haven to collaborators. So I think it's entirely understandable why Ukraine would then reach this conclusion of we don't want this guy. And so that makes a lot of sense to me.
Yeah, a question right there.
Thank you for this fascinating discussion. I have one question about practices of between East and West, because when you were talking about this Travniki card given by the Soviets, you gave some political argument in order to explain why the Soviet gave these documents. But as far as I know, especially the second wave of trials in the Soviet Union and also in the West, the practice of circulation of documents was quite usual between East and West, And so I wanted your opinion on this question about circulation of documents for trials, and the question of such a kind of international collaboration in these trials.
At least with respect to, for example, I'm going back to the late 1970s. If you look at the cooperation between the Soviet Union and American investigators, it's not particularly good. You do not find a lot of information. You do have various people within the U.S. Justice Department trying to create back-channel communication with the Soviets. I talk in my book about some of these figures who tried to create these back-channel communications. But for example, some of the people in the Justice Department are actually running into problems with people in the U.S. State Department. The U.S. State Department doesn't want to show that we need the cooperation of the Soviets for anything. So even within the U.S. government, you find certain people eager to foster channels of communication, and others very, very resistant to doing so. And I think it's also the case that if you look at the relations when Israel was mounting the Ivan Grozny trial, Israel had a lot of trouble receiving information from the Soviet Union. The only way that they were able to secure the actual Cherniki, that famous ID card, was through the personal intervention of this Armin Hammer, who appealed directly, who actually was one of the few U.S. businessmen who at the time was fostering good relationships, or trying to foster good relations between the Soviet Union and the United States. He engaged in personal intervention for the purpose of trying to get that card to the Israelis. But in terms of the cooperation between the United States, the Soviet Union, the Israelis, and the Soviet Union, it was very poor, and it was only done through back-channel communications.
We had a question right here. This young woman hasn't spoken yet. Up front, right there.
Thank you very much for your presentation. My question is, to what extent do you think the legal advancements that allowed Danyliw and others to be convicted in Germany will influence future prosecutions in other countries and in different conflicts?
Yeah, it's a nice question, and it goes a little bit to, this little bit that we were talking about the International Criminal Court, because the theory of, again, I don't want to get too legally technical, but the theory of what I describe as functional participation that's pioneered in the Danyliw case, it starts to look a bit like the theory of the notion of joint criminal enterprise that has been used in particular at the Yugoslavia Tribunal in The Hague, the ICTY, the International Criminal Tribunal for the former Yugoslavia, which has then now found its way into the fledgling case law of the International Criminal Court. So it is interesting how you do find this kind of cross-hybridization of legal theory between these international courts and this domestic national court in Germany. The other thing that I think I should mention is that, at least from my own view, that the value of this breakthrough in Munich shouldn't be measured simply in terms of the additional prosecution that it sponsors. I do think that that the law is, one of the things that in a lot of my writings I try to argue that the law is a cultural discourse. It's a way that we express social meanings, and so there's something kind of important about framing that kind of the right theory of culpability in state-sponsored atrocities on the legal level, because law is one of our crucial social discourses.
We had one final question.
A philosophical question. People like Danyliw were born and grew up in the Soviet system at a time when there was extreme social, psychological, physical violence, where life was not a value, where value was defined by the state in the service of the party. Given that, and given eventually he flips into another society, which is the German Nazi one, that has similar standards, can we then try him according to our moral compass? where people like him would have a completely different one through what could say no fault of their own.
Again, this requires a certain level of psychologizing, and it's not like I knew Danyliw personally. It did seem to me, though, that Danyliw made many statements. He was quite a silent figure in the Munich trial, but over the course of years, he made many, many different statements. And I would say that he was, again, this is not to say that your question can't be asked of other persons. I'm just not sure if Danyliw is a good exemplar of the phenomenon you're describing. Because it does seem like he was never particularly inculcated with Soviet ideology. I mean, he grew up in a rather anti-Soviet climate, and he seemed to be, he was a pretty savvy, independent thinker. Not by any ways was he profoundly educated, but he also seemed to have, relatively intelligent, independent thinking person. So the phenomenon you're describing about someone whose mindset has been almost programmed by a totalitarian system, I don't think it necessarily applies in particularly good shape, in good form, with a person like a Danyliw.
Lawrence, I think Boris' point was not less the ideology than the experience. That Danyliw, as a teenager, experienced both the famine and then the Great Purges in Soviet Ukraine. That is, he was witness to how, in little regard, the state had towards human life. He witnessed, literally at the village level, what mass violence or mass arrest mean, and then as a young man in his 20s is put into this other extraordinary situation. I think that was the gist of the question.
Well, I mean, if so, then I'll focus on that level. And again, I suppose I would go to the question, I think we'd be in very hazardous moral terrain if we believe that the fact that people suffered ways that I find unimaginable in their youthful years then is an argument for having no legal liability for participating in acts of extermination. I think that's a hazardous moral argument to make and a legal argument to make. I would be much more comfortable again with the kind of almost the theory that was articulated in Nuremberg with respect to superior orders, which is we have to think very carefully about how to punish these kinds of people. And does someone like a Danyliw deserve the kind of punishment of someone like Heinrich Himmler? I think it would be grotesque to make the argument that he does. But again, I still think that if we're going to maintain our moral compass, I think it is important to recognize that even these lowly foot soldiers in genocide who themselves suffered all sorts of incredible deprivations in their life, that we still have to say there was a wrong that they committed. And even if that punishment has to be mitigated to recognize those circumstances, we still need to make that symbolic gesture of punishment.
Great.
Yes.
I think that that's a great note to end on. And this definitely relates to a lot of the conversations we're having at the seminar as well. So thank you so much for taking the time to speak with us about your book. And thank you so much. Thank you to Lawrence Douglas.